Good morning, Professor. Is it professor or advocate? Which do you prefer?
For practice purposes, advocate.
All right.
Justice.
Well, if I'm to refer, I'm to address your advocate's cap, then it will have to be missed, and I don't want to demote you. So I'll just call you Prof. How are you?
I'm fine, thank you, Deputy Chief Justice.
You were here exactly around this time in 2022, weren't you?
Yes, Chief Justice.
What have you been up to in the past year? Have you been good?
You mean the previous interviews?
No, I mean, what have you been doing with yourself since?
Well, after my previous appearance before the JSC, I've been afforded opportunity to act. And when I came here last time, I've acted for 40 weeks. And now I've acted for 55 weeks. Last time when I came here, I've written 53 judgments. Now I've written 70 judgments.
Wow.
And in the meantime, I have then progressively acquired skills and practice in judging.
You've been busy.
Yes.
No, that's good to hear. Let's backtrack a little. You have 4 degrees, a BURS you obtained from Forte.
Correct, Deputy.
LLB you got from VETS.
Correct, Deputy.
And an LLM from UNISA.
Correct.
And an LLD from UNISA.
Correct.
And what's your area of specialty? What was your LLM on?
My LLM was on fundamental rights, and my LLD was on supervision of local government under the new constitutional dispensation.
You wrote a book as well, didn't you?
Yes, I wrote a book published by JUTA on supervision of local government.
You developed it from your thesis for your LLD?
I developed it from my thesis and add a few things.
All right. For the benefit of those who have not heard you while you were on that seat before, you have had quite a remarkable career. You started out as a police officer.
Yes.
And in that sphere, you worked your way up to the rank of sergeant.
Yes.
You would have joined the police force straight from high school, but you were 20 or somewhere around that age.
Yes, I was 21 years old.
And then you left the police force in 1988.
Yes.
To do articles.
No, to study.
Of clerkship.
To study at Forte.
That's not what your CV says, though. It says, oh, sorry, you're quite right. It says you're a police sergeant from 1 January 1987 until December 1988. All right, no, I'm confusing you with another candidate. So you left the police force in 1988 and went back to university, back to school.
Yes.
And did your BURS and LLB, I imagine?
That's correct.
All right. And then you started your articles in 1996.
Yes.
How long were you at the sidebar?
It was 4.5 years, Deputy Chief Justice.
And you were a principal attorney of your own firm.
That's correct.
By the time you left.
Yes.
The profession, and then you went back to public service.
Yes.
To do what?
I went back to Department of Safety and Security there. I was the head of department, and then I joined municipalities. I've been a municipal manager.
In 2 municipalities
Yeah,
for a period of 5 years, I see.
yeah.
But during that time, you also chaired the Appeal Development Tribunal.
Yes.
What kind of work did you do in that body?
Well, it was to do with development tribunal. So whenever there is development, then they will apply to the development tribunal to approve those development. And then I was sitting there on the appeal board.
Okay. But then you left all those things and decided to join the academia
Yes,
to date.
yeah.
Which subjects have you taught in your academic career?
When I was at Northwest University, I taught family law, interpretation of statutes, and property law. And when I joined UNISA for the first 4 years, I taught law of evidence and civil procedure. And after that 4 years, then I taught constitutional law and local government law.
Right. But then in 2021, you decided to join the bar.
Yes.
Do you still teach?
I do pro bono. I only promote masters and doctoral students for UNISA.
Okay. You have published several legal articles in these areas of specialty
Yes.
of yours. How many? Are they too many to count?
I cannot remember, but there are many.
Yeah. All right. You have already told us about the length of time you have had on the High Court bench. You said it's how many weeks?
55 weeks.
55 weeks.
Yeah.
And I imagine that during that long period of time, you've sat in both the civil and criminal courts,
Yes.
doing a wide spread of work.
Yes.
Okay, both civil and criminal
Both civil and
trials and appeals and motions.
Yes.
Okay. How many judgments? 70?
70 judgments.
Okay. Any of them reported?
No.
All right. Any appeals taken against?
Yes, the one appeal was taken and my judgment was overturned. It was a full bench judgment, a criminal appeal.
Okay. When you were last year, there had been an objection against your candidature. Well, it was a concern really that you did not have sufficient experience to be permanently appointed to the bench, and it had been suggested, it was from the aft, and they suggested that you should be given further time in an acting position, which happened. And they have come back now, and they report that you have improved. To use their words, you've improved tremendously during your acting stints. And they and the other professional bodies who have commented speak well of your judgments, and they say they support your candidature.
Yes.
You would not have any complaints against that, I imagine. Okay. All right. I am going to give the commissioners a chance to put questions to you if there are any. And we will start with the Judge President of the division to which you are applying, J.P. Boyolwati.
Thank you, TCJ. Good morning. Like the TCJ, can I call you Professor?
Thank you, Judge President. Good morning.
Good morning. I want to emphasize Professor because I believe that's where your strength is as a professor, as an academia, with lot and extensive background in that field, unlike being an advocate where you've been for 2 or 3 years only?
Yes.
And how has your academia background assisted you in writing your judgments?
Mr. President, it have assisted me on many ways. Firstly, with regard to extensive training on research, I do my own research, and also training on typing. I type my own judgment and make work easy for secretaries. Further, the knowledge, analytical skills that I acquired in research and academic, I found them to be useful in analyzing cases, in hard cases. So they've been very helpful.
Yes. You have acted during the time when I have been the judge president, both in Durban and in Pietermaritzburg.
Yes, Judge President.
And in particular, Durban, how have you found the workload?
Durban is a bit different from Pietermaritzburg. Durban is very busy, and there are a lot of issues like your Rule 43, your urgent application, but I've coped with the workload.
Yes. Those are the comments I've received from some of my colleagues about your performance, that you seem to have coped well, and you haven't complained once when more work was put on your desk.
Yes.
In fact, most of them that I have spoken to. Most of them also, I think the age issue has become irrelevant after the recommendations yesterday. They believe that you worked well, contrary to what one would think, particularly if one has regard to your age, which is about 62. I have nothing about age, I must be upfront. I was also quite impressed when you came back to me when your criminal trial role collapsed and you made yourself available.
Thank you, Judge.
Yes, and in there, I gave you an opposed application, which within few hours, I think because it was dealing with local government issues, you were able to come back and identify the issues and confer 1 or 2 things with me.
Thank you.
Yes. Now, the only issue that seems to be raised, as something that we must take into account is the judgment from the Supreme Court of Appeal, S versus Pile, where the judges, they say that you ignored certain facts when you decided the matter.
Yeah.
That was a full bench decision. You sat with the retired Prof van Amstel J.
Yes.
And he agreed with you.
Yes.
Yes. What are your comments to the comments of the Supreme Court of Appeal?
Thank you, Chief Justice. The judgment itself was a bit complicated because it dealt with interpretation of statutes. It dealt with interpretation of Section 93, Tier 1 of the Magistrate Court. And there have been sharp judicial opinion on that issue. There have been a lot of conflicting judgments. In Eastern Cape, there was Lichona judgment. In Gauteng, there was Ngomane judgment. In KZN, there are about 4 judgments. All these judgments actually were conflicting. And my interpretation of Section 93, which provided whenever an accused person is stand trial before a regional court magistrate, the magistrate must be assisted by 2 assessors unless the accused person requests that the matter can proceed without assessors. So in interpreting that Section 93, I opted to follow the KZN division, especially the case of State versus Nomalo, which was Lob's judgment. I regret, JP, that there was an oversight on that. I should have thoroughly interrogated all judgments.
Yes, but what interests me, as you have said, there's a lot of divergent views on that issue, and hopefully soon the CC might pronounce on the issue, because there still continues to be, because it seems to have been the issue that the accused rights were explained at a pre-trial conference, and I don't know whether it was a different magistrate in terms of the assessors.
Yes.
And then also at the trial, there was no explanation. So I don't know if you recall, was it a different magistrate that dealt the pre-trial and a different one that started the trial?
Yes, Judge President, it was a different magistrate at the pre-trial, and it was just a rewriting hand note, which actually did not explain what exactly was explained to the accused person, because then I was taking from the Gaia judgment, where paragraph 8 of the judgment, so Supreme Court judgment, where it was stated that the starting point is that the regional magistrate should inform the accused person that as a matter of law, he or she is required to sit with assessors. And what then happened in this judgment is that there were retyped notes that the accused was informed of assessors, understood, and Laikman, who was the attorney then, confirmed that the court may dispense with assessors. And during trial, the magistrate, which was then a different magistrate, wanted to know from the legal representative whether he confirmed whether the issue of the assessors is still the case. So then I was of the view then that because the Natal division, in about 3 cases, Hlachwayo, Ngumalo, have actually decided that, firstly, the magistrate should inform the accused person. He should talk direct to the accused person, not through an attorney. And the accused can only make a choice whether he wants to dispense with the assessors once the accused person has understood the nature of that Section 93. That was the issue.
Yes, and in such matters where the conviction and the sentence have been set aside, it's up to the Director of Public Prosecutions to reinstate those charges because it was a technical issue. Am I correct?
Yes.
Yeah. And then finally, there's a full court decision. I don't know if you know about it. I think you were confirmed by Stein, Bezet and Go CJ, but it almost caused a conundrum in my court because they were not agreeing on the order. But ultimately, after lots of talk, you were confirmed. It just shows the extent of the complexity of the matter, where 3 judges were seeming to not be agreeable. But as I say, in the end, we do have an order. Thank you, TCJ.
Thank you.
Thank you, JP. Premier Dube.
Thank you very much, Mr. J.
We seem to have lost you. Are you still there?
Okay, yeah, there you go. Can you hear me now?
Yes, we can, and see you too.
Thank you very much. Just to office, Prof, especially that Prof exposed to local government, and I always feel that there is a need for more work to be done around the matters of local government, even around issues of traditional leadership as pertaining to local government. We've seen a number of judgments that delay when it comes to issues of local government. What do you think, in your view, is impacting on those long outstanding judgments when it comes to matters of local government?
Thank you, Honorable Premier. Firstly, it impacts a lot because local government, as the released sphere of government, there is concern with delivery direct to the people. And whenever this matter take too long in court.
I'm sorry, Prof. Mathenjwa, you soft-spoken. Can you just speak closer to the mic? I'm struggling a bit to hear you.
Thank you.
I'm hard of hearing.
Thank you. Local government is a sphere of government that is closer to the community, and it's a sphere of government that is concerned with service delivery. If judgment are delayed, then it means that because judgment will be delayed because there are disputes between the parties, then service delivery will be affected. Therefore, knowledge and adequate application of local government law within a reasonable time, it's important.
Maybe DCJ, what do you think, Prof, should be done then to ensure that we avoid such delays? Because, as you correctly say, it does impact on the lives of people, but also in fact, it impacts on the efficiency in the delivery of services by government.
Judges, like all other people, are accountable. Therefore, the value of accountability requires that judges should deliver their judgment in time, because if they do not deliver their judgment in time, then they are failing the very value of accountability enshrined in the Constitution.
Okay, thank you very much, DCJ.
Thank you, Premier. Do you have any questions, dear?
Good morning, Prof. No, I have no questions.
Good morning, Judge President.
I thought you were going to say Molo Mhlobo wam.
Sorry?
I thought you were going to hold a Molo Mhlobo wam. That's what you threatened. Prof. Maruma Khai.
Thank you very much, DCJ. Good morning, Prof. Mathenjwa.
Good morning, Prof.
I have a question for you arising from the judgment that you penned. I'm just trying to. It is a judgment that dealt with the intersection between the Recognition of Customary Marriages Act and the Administration of Deceased Estates Act. You remember that judgment? I'm just
yes,
trying to get to it now. Yes. And I'm not criticizing the outcome, because I think you are probably right. But I'm asking you because of the difficulty of these kinds of cases and some of the judgments that have came. And of course, one needs some clarity when reading these kinds of judgments. One, the the marriage was declared valid post the death of one of the parties.
Yes.
Yes. And in paragraph 1, you state correctly that this is the applicant seeks an order declaring the customary marriage to be valid. And then you deal with Section 3 or Section 1 of the Recognition Act, the requirements of the marriage. But it doesn't seem to me that you grapple with what authorizes you to declare the marriage valid, even though the deceased is no more. I mean, it is possible, but in your judgment, it doesn't seem like you deal. It seems like you take it as a granted that that can be done. I'm not sure if it is just stylistic or do you have anything to say about that? Because when one reads these kinds of judgments, one would want to understand on the basis of what would that kind of order be made? Because somebody because some of us, we are teaching, you know that. So when I'm using this judgment to teach family law, students might ask, but is it possible for a marriage to be declared valid when the person is dead? I mean, you and I, we know it's possible, but I'm just saying from the judgment, it doesn't seem like you grapple with that.
Thank you, Prof. The starting point is that, as you know, it's not a requirement of the customary marriage that it should be registered. So there was then evidence, there was affidavit from the deceased family, from the husband family, from the traditional headman who was present when the marriage was officiated. So based on that evidence, and based on the fact that it is not a requirement that customary
my apologies, Prof. I'm asking a different question. You are right. There's no requirement for that marriage to be registered. The Section 4(9) of the Customary Marriages Act makes it absolutely clear, notwithstanding the non-registration of that marriage, that cannot invalidate the marriage. It can be registered later, even years later. I have no difficulty with that. I'm more on Section 4, subsection 7, which allows you to declare this marriage. But the question I'm asking is, why don't you deal with Section 4, subsection 7, which at least just to show that I'm going to grant this order based on this provision? That's what I'm conversing with you.
I felt it was important, firstly, to declare the marriage that it was a valid marriage so that the spouse could be appointed as the executor based on the fact that she was the wife of the deceased. If the marriage was not declared valid, then how would one say that the spouse was the wife of the deceased? That was my reasoning.
Well, I'll leave it there. Thank you very much, DCG.
Thank you, Prof. Commissioner Singh.
Thank you very much, DCJ, and let me declare that I do know the good professor. If you look at his answer to question 8, he belonged to an organization that I belong to and still belong to. But he's not there anymore. But notwithstanding that, Prof, I think I want to take advantage of the fact that you've been an academic and a very good one at it. You must have heard the CJ announce the other day that academics will be allowed to apply for vacancies in the Concord. I just want to know, in terms of your experience as an academic, where do academics find time to sit on the bench? Because you'd either have to go on sabbatical or resign from your position. What happened in your case, and what informed you moving from academia to the bench? Thank you.
The only reason why I took early retirement is when I was given stint to act. Firstly, I applied for leave, then I was given 30 days. But then I realized that because my passion now was with the bench, I rather resign so that in case I'm given more stint to act, I'm available. Then it worked, because after resigning from academic, I was given more stint to act.
So that would seem to be a calculated decision. which worked out for you. But generally for academics, I mean, what position will they find themselves in? You were fortunate that you had acting positions and then you are here before us today. But generally for an academic, because it's well and good for us to say that academics can apply to the Constitutional Court. But, practically, will it not be a bit problematic?
Well, universities have different policies. It depends on the policy of the university. They have different policies. Other universities allow academics to practice, and if academic practice, that in fact enriches their teaching because they combine practical and theory. So for me, depending on the policy of the university, that is workable.
Thank you, DC. Jay, I've been enlightened, and I think we've been enlightened.
Yeah.
Thank you.
No, thank you very much, Commissioner Singh. Are there any questions for this candidate? Oh, JP Mlambo.
Thank you very much, Prof. Good morning.
Good morning.
By the way, me and you last met during the sergeant training, isn't it?
That's correct, JP.
Yeah, and I take it you've given up on me. That's why you're sitting here today for KZN.
JP.
You don't have to respond. Just to follow up on this question about academics, my experience is academics struggle to, those in full-time employment of the universities, they struggle to avail themselves. They can only do so when they are on sabbatical, mostly. Because they've got responsibilities to their students and the university.
Yeah.
How have you managed to bypass those problems?
It's correct, Judge President. That bothered me a lot, but that is the reason. When I resigned as an academic, I still had a lot of years to go as a full professor, but I have to make a choice because then I was invited to act. Then I realized that because in academic, your clients are your students should be prioritized. Yes. Then I thought I rather resign, hoping that I'll be given more acting stint, and that happened.
Yes.
Yeah.
My other half question, DCJ, is I've had a number of academics coming to act in Gauteng, those who were able to do that. And my experience is that if you put them in work areas like unopposed motions, and I think civil trials as well, they tend to struggle somewhat with the procedural issues of hearing the matters, but on substantive issues, they don't have a problem. What was your experience?
It's true, Judge President. My experience was different because firstly, I served articles as an attorney, practice as an attorney. I served pupillage as an advocate in Pretoria, practice as an advocate, I was an academic, so I have that combination of, but motion court, it's very challenging because motion court, you are on your own as a judge. If you are not familiar with the court procedure, you are likely to struggle. I agree on that, Judge President.
But your experience, as you say, serving articles and being in practice, didn't helped you, that is, in coming to grips with the High Court litigation?
It helped me a lot, Judge President, because in most cases I will even refer to my pupillage notes because everything is contained there and developed from there. But whenever legal representative said something, because I will know where to get the answer.
Yeah. And my last question, DCJ. I think in all fairness, I put the same question to the previous candidate. Your judgment in the N2 eco-fuel CC matter,
Yeah.
you decided a number of issues there. I mean, the order says you dealt with a special plea, 2 special pleas, as well as non-joinder. But there was also an application to strike out in that judgment. Now, as I say, in fairness to the other candidate as well, when I read this judgment, I read throughout until you dealt with the application to strike out and then you went further. I couldn't find anywhere where you tell me early on what are the issues in this matter, what are you deciding? Am I being unfair on you?
No, you are correct, Judge President. Even in the course that I attended on aspirant judges, that was emphasized that you should state what are the issues involved. I've done it in other judgments, but for some reason there might have been oversight on this judgment.
Yeah.
Yeah.
No problem. I think your judgments generally are short, to the point, and succinct, and that impressed me. And if I may say this, DCJ, during the course that Judge Matopo ran, that I'm talking about, the Prof was one of those very actively involved participants in that course, including another Prof who's sitting in this room, whose name shall remain unnamed. Thank you very much, DCJ.
I think we can guess with accuracy which other Prof that is. Commissioner Bernard?
Thank you, DCJ. Prof, I want to just take a matter further that was raised by the JP, and that is specifically the matter of State versus Pillay. It seemed to me that the explanation given was more with reference to the law and maybe the challenges in that regard. But the judge, the High Court does say the SCA at least does say in paragraph 41 that the High Court ignored the facts as disclosed on the record. And then again, later on in that paragraph, it erred both in respect of the law and its in respect of the law, relating to the section and in its application to the facts. So specifically on the factual misreading, it seems like the court yourself and Judge van Amstel, missed something in regard to the facts there. What have any comment on that?
No, thank you, Commissioner. It's true. It seems as if the statement in the pre-trial conference, firstly, that the accused person were informed of the use of the section, they understood, and that the attorney confirmed that they can do away with the assessors, and thereafter the accused person also confirmed that. I think the Commissioner, it boils down to the very interpretation, even that is reflected to the record. It can be said we overlooked that, but our interpretation at the time was that if the regional court magistrate did not explain the nature of Section 93, that will be irregularity. That was our interpretation at the time.
Although it seems that if one reads the appeal case, the Director of Public Prosecutors, KZN versus Pillay, then it seems that the court says that the magistrate did make a note that was explained in court. So it seems like that note was not accepted by yourselves.
No, Commissioner, it was not explained in court. There were notes, handwritten notes of the pre-trial conference. In court, all what the magistrate says was to ask the legal representative whether it is still the case that the assessors were not needed.
Thank you. I'll leave it at that. Thank you.
Thank you.
CJ, thank you.
Thanks, Commissioner Bernard. Prof, there are no further questions for you, so that means we have finished your interview. Unless there's anything you want to say to the Commission, you are excused, and thank you very much for making yourself available.
Thank you very much, Deputy Chief Justice.